declared a global pandemic.
We're going to have a rough week.
Scouring my agenda book and trying to find the agendized item.
Bexar County has seen a sharp rise.
These fraudulent health tests.
The backbone of the U.S. economy is small business, and we want to keep it that way. But more small businesses are being eaten up by big businesses, who manipulate the media and their political connections to destroy their competition at a time when the market conditions are ferocious. The reason this lawsuit matters to every Texan is because it's about a growing economic tactic, nationally and locally, in which big fish in business will disparage and damage the reputation of small fish in business through unethical and improper relationships being created whereby the media's need for revenue through advertising, donations, and sponsorship gives the media donors sway over what articles should or should not be written. Lawyers are warning that Texas business owners' rights may be taken away if the Texas Supreme Court rules that the media and their sponsors are more powerful than the laws to protect you against business disparagement. According to court documents, the Texas Tribune and ProPublica admitted to willful and intentional interference, also known as conspiracy, against MRG Medical in the Travis County District Court to shield their wealthy donors from testifying in the case. Court documents claim the gist of the article is false and misleading, and expose that $1.5 million has been donated to the Texas Tribune by the Tobin Foundation, of which its chairman and leadership, and former leadership, are also co-founders of Community Labs. MRG wants the Supreme Court to uphold the rule of law and affirm the district court's ruling to allow this case to proceed, or, at minimum, grant the petition of review and allow all the legal arguments and evidence to be presented to the court for consideration. MRG is a pioneering telemedicine business ahead of its time and believes that the Texas legislature did not write the law on disparagement to have exceptions for wealthy media donors and their well-connected law firm. Every Texas business person could have their business destroyed by media and lawyers funded to distort your business, the media, and fairness in the law. MRG alleges that the co-conspirators hatched a plot to enter the testing and telehealth market and overtake their competitors through politics rather than innovation. The plan came to fruition on the founding of Community Labs, LLC, on September 16, 2020. 9 days later, the Texas Tribune and ProPublica published an article that MRG says created a substantially false and defamatory impression by omitting material facts or juxtaposing facts in a misleading way. Less than 2 weeks later, on October 6, 2020, Bexar County Commissioner's Court gave the entire $2 million of its testing funds to a newly created organization, Community Labs, LLC, whose founders happen to be major donors to the Texas Tribune. Community Labs held itself out as a nonprofit. A search for Texas tax-exempt entities and a search for IRS tax-exempt entities named Community Labs reveal no hits. Despite MRG never receiving a dollar in government funds prior to the article's publication, the main benefactor of the article's disparaging and false implications was Community Labs, who had significant financial ties to the Texas Tribune. County Commissioner Tommy Calvert originally allocated, with the Bexar County Commissioner's Court's approval, $2 million for COVID testing at all urgent care centers offering rapid tests for those who could not afford a $50 to $125 rapid antigen test. The 353rd District Court in Austin said that MRG's case was neither frivolous nor without merit and could proceed. Yet, the Texas Tribune and ProPublica, represented by one of the largest law firms in Texas, Jackson Walker, appealed. The Court of Appeals reversed the trial court's ruling, and the matter now sits before the Texas Supreme Court for final resolution. Without the Texas Supreme Court taking up the case, MRG would be without any legal remedy to seek justice, and more importantly, the case would be dismissed despite MRG providing proof of every element of its business disparagement claim. According to MRG's lawyers, the article falsely implies financial impropriety between MRG and its former unpaid advisory board member, Bexar County Commissioner Tommy Calvert. Their article juxtaposed a sentence about conflicts of interest right after writing that Calvert had dinners and spent time at the Kentucky Derby, even though Commissioner Calvert provided bank records to the Tribune and ProPublica for them to publish, showing Calvert paid for his airfare to the Kentucky Derby with MRG's CEO, that Calvert paid his own hotel and for his food, even telling them to show that he went twice to Popeyes. According to the court transcript, MRG's lawyers stated that the Tribune and ProPublica article never defined for readers what the state conflict of interest law said, but used disparagement by implication to give the gist that there was financial impropriety and violations of Texas law. The article implied that the violation of law also extended to false implications that MRG was utilizing tests that were unauthorized for use by the FDA. The 353rd District Court, who heard the case, pointed out that people are free to go on trips with contractors, and questioned why the reporters even brought up the Kentucky trip after receiving the information of him having paid his own expenses, arguing that it wasn't illegal for him to go to the Kentucky Derby if he paid his entire trip himself. Texas law states that county governments do not have to bid for contracts under $50,000, but the Tribune and ProPublica juxtaposed words of another county commissioner to imply that MRG Medical CEO was engaged in something that was going to cause him to end up in prison. MRG's lawyers argued in court that the Texas Tribune and ProPublica were acting with malicious intent and utter disregard for the truth, to imply that MRG engaged in illegal conduct, even though there is nothing illegal about the business strategy to attain contracts under $50,000 with a government entity. MRG's lawyers were able to get affidavits from both Commissioners David Hall and Vern Lissy, stating that they had no evidence of criminal activity. One commissioner stated that his comments were about an unrelated conversation he had overheard, even though the Tribune and ProPublica juxtaposed their comments to allegedly disparage MRG Medical. Soon after the pandemic began, Commissioner Tommy Calvert drafted an April 2, 2020 memo to his fellow county commissioners and staff to call Harvard and Columbia University-trained Dr. Henry Legere, the head of MD Box, the medical provider of MRG's COVID tests. In the confusion about testing, Calvert employed them to pick up the phone and call his legal counsel so they could understand their product, process, and legal status with the FDA. Commissioner Calvert said, instead of slowing down the testing process, the Commissioner's Court should do its due diligence and order 10,000 of these tests to first responders, the indigent, and the critically ill. The 353rd District Court agreed with the plaintiff that there was nothing illegal with that. In response to implications from the Texas Tribune and ProPublica that the WANDFO COVID tests were unauthorized, MRG and Commissioner Calvert's legal counsel submitted legal proof of FDA authorization, which included correspondence with the FDA outlining why MD Box and MRG's stated use of the tests was in compliance with the FDA guidelines. MRG provided multiple canceled contracts and affidavits proving that prospective clients would no longer do business with MRG because of the Tribune and ProPublica's article. The Third Court of Appeals reversed the trial court's denial of the Tribune and ProPublica's Texas Citizens Participation Act's motion to dismiss because MRG Medical never sold COVID tests. In substance, the appellate court's opinion faulted appellees for not actually manufacturing and directly selling COVID tests to consumers. The fact that the company asserting a business disparagement claim does not manufacture the specific products that are incorporated into the services it provides to the public should not be dispositive of any additional analysis of the disparagement elements. Further, the Court of Appeals' opinion did not even contain a discussion regarding the implication and gist claims that were relied on by the trial court in its ruling. In correspondence between one of the reporters and FDA official also refutes Tribune ProPublica reporter Viana Davila's statements and directly counters the implications set forth in the questions, even responding to one of the quotes used in an email from Davila as misleading. Despite the reporters being aware of this information, the article implies a get-rich scheme where tests were fake or had no supporting documentation. MRG's lawyer demonstrated how the Tribune reporters then used a quote from Hays County Judge Ruben Becerra about how he would never use FDA unauthorized or illegal COVID tests to make disparaging implications about MRG. Judge Becerra clarified in an affidavit that his statement was general and that he was not referring to MRG in that quote and that he was given erroneous information. In the juicy details of discovery, MRG's lawyers got the Texas Tribune and ProPublica to admit that they never found any evidence of illicit or illegal relationships that would violate any conflict of interest laws. As multiple lines of the lawsuit proceed, MRG's core contention remains. The article created a substantially false and defamatory impression by omitting material facts and juxtaposing facts in a misleading way. If the Texas Supreme Court does not grant MRG's petition of review, the Court of Appeals' opinion, which reversed the trial court's decision based on the fact that MRG did not manufacture the COVID test, the Texas court system should uphold the facts and the law. Texas businesses and individuals should be allowed to get their day in court, and at minimum, MRG should be allowed to present its full case to the Texas Supreme Court.